I'm going to tell you a story. It's January 19th, 1960. Police in Illinois are investigating a murder. And at 2:30 a.m. in the morning, they arrest and interrogate the brother-in-law of the deceased victim. He's a man named Danny Escobedo. Danny's 22 years old, he's a Mexican immigrant, and he has no criminal history. The police hold Danny until 5 p.m. the next day, and for the 9.5 hours that Danny's in police custody, he doesn't say a word. Without further evidence, the police have to let him go, and Danny gets out of custody and immediately hires a lawyer. Well, 10 days later, the police come back and they rearrest Danny. This time, they come at it with a different tactic. They tell him that a friend of his has implicated him in the murder, and Danny asks to speak to his lawyer. The police tell Danny that his lawyer doesn't want to see him. Danny's told that he can go home, but only if he pins the murder on his friend. He's told that if he gives the statement that the police are looking for, he'll be granted immunity from prosecution. And eventually Danny does just that. He admits to knowing of the plot to kill his brother-in-law, and in Illinois, someone involved in a murder plot is complicit in the murder itself, and just as guilty as the person who carried out the crime. From that moment on, Danny's fate is sealed. He's convicted, but he appeals, and his case goes all the way up to the United States Supreme Court.
Escobedo petitioner versus Illinois.
In deciding Escobedo's case, the court stated the following: no system worth preserving should have to fear that if an accused is permitted to consult with a lawyer, he will become aware of and exercise those rights. If the exercise of constitutional rights will thwart the effectiveness of a system of law enforcement, then there is something very wrong with that system. The court held that when an investigation is no longer a general inquiry into an unsolved crime, but has begun to focus on a particular suspect, then that person who's been taken into custody, and when the police carry out the process of interrogation that lends itself to eliciting incriminating statements, when that suspect has requested and been denied an opportunity to consult with his lawyer, and the police have not warned him of his constitutional right to remain silent, then that person has been denied the assistance of counsel that's guaranteed by the Sixth Amendment to the United States Constitution. Now, Escobedo's case was decided on June 22nd of 1964. 2 years later, the Supreme Court made this rule absolute in a case called Miranda versus Arizona. And in that case, the court found that the police must not only honor someone's right to remain silent or to have an attorney, but they also must advise them that they have that right in the first place. Now, the Miranda Rights are not complicated, and they've been around for about 50 years. And there's only two of them. You have the right to remain silent, and you have the right to have an attorney. And the police have to tell a suspect that they'll get a free attorney if they can't afford one, and they have to tell the person that they're about to interrogate that if they do talk, then the words that they're going to say can be used against them during the court proceedings. So when did the police have to tell you your rights? Well, there's two things that have to happen before your Miranda rights are implicated. There has to be a custodial interrogation. What that means is that you have to be in custody. So that's more than just having the police talk to you. The police are allowed to interview witnesses and have conversations with people on the streets and perform the basic aspects of an investigation. But once you're placed into custody, then police have to advise you of your Miranda rights before they interrogate you. So custody is broader than just being placed in handcuffs or being placed in a jail cell, although those are two of the factors that the court will consider. Custody means that your freedom has been denied to an extent that a person would not feel free to leave that encounter. Now, that's a case-by-case analysis, and courts come out on different sides of that issue in different cases, but there's a number of factors that courts are going to consider in every case. So they're going to look to see, did you have a gun pulled on you? Did you ask to leave? Were you told that you couldn't? Were you placed in handcuffs or in the back of a police vehicle? Did the interview take place at your house, or did it take place in a police facility? Were there a number of police officers around you? Were you so intimidated that you would not feel free to leave that encounter? Now, the next question is, did the police officer interrogate you? An interrogation also has a broader definition. It means where you asked questions that were designed to elicit an incriminating response. That's what interrogation is. So if you're in custody and you're chatting about the weather, now that's probably not going to qualify as interrogation. But if a police officer starts asking you questions about the case, about the situation, in an attempt to get evidence that he's going to use to help bolster the prosecution's case, well, then you're being interrogated, and before he does that, he has to advise you of your rights. So what happens if they just don't do that? Well, then the evidence is suppressed. And that's the remedy for a violation of your Miranda rights. What courts say is that police officers and district attorneys and law enforcement in general don't get to benefit from the violation of somebody's constitutional rights. So if a court finds that statements were elicited in violation of your Miranda rights, then they'll suppress them, and those statements are treated as if they never existed in the first place. So prosecutors can't talk about those statements in their opening statements. Police officers can't testify about them during their examination. That doesn't mean that the case will be dismissed. If your rights are violated, police officers, district attorneys, they can still proceed forward with what evidence was lawfully obtained. So, they could use the police officer's physical observations. They could use any statements that were made before you were placed into custody. But the statements that they obtained in violation of your constitutional rights cannot be used as part of the DA's case. That's the answer to when police have to advise you of your Miranda rights and what happens when they don't. My name is Austin Lux. I'm a criminal defense attorney. I practice in Colorado Springs, Colorado. And I want you to know your rights and know the law.